pass the bar. You're going to pass the bar. In these lecture shorts, you'll get good at torts. Know the laws you've got to know. So let's start, 'cause you've got an awful long way to go.
Hello and welcome to Passing the Bar, a video lecture series brought to you by Delaware Law School. My name is Professor Brett Bendistis, and today we're going to cover a lot of anecdotes. We're going to talk a lot about law, so let's start with a really quick anecdote about the theme song you just heard. So my family, we have my stepdaughter Gemma, and she loves Wicked, and so we've been listening to the Wicked soundtrack for like months and months and months. And I heard it, and there's a word cohorts. If you're familiar with the song Popular, that's obviously what the song was after. And it rhymed with torts, and it was our family's goal to figure out a way to make a theme song, right? Every good show has its own theme song, and I am not so bold to sing my own theme song. I'm not Shawn Michaels by any means, but this was a family effort to make sure that we had a cool song to begin everything. I hope everybody liked it. I love it to death. I sing it like all the time. My 2-year-old daughter just started singing it too, so that's very cool. Now, going into what we're talking today, and again, this is anecdotes. I'm going to be talking about non-MBE topics that are on the bar exam, right? We're going to talk family law corporations, wills and trusts, secured transactions, and a little bit at the end, we're going to cover agency and conflict of laws. Now, I'm not going to teach you these topics because you have resources to do that, right? You have plenty of things that are going to teach you the ins and outs of these really specific rules. What I would like to do is to give you some practical understanding of what these topics are really about. Here's what I mean by that. At the end of the day, this is a practical exam that's supposed to test your ability to practice law. I have had the pleasure of practicing as a general practitioner my entire career. I worked at a law office that had it was like out of a house on a street. We have people who would just walk in and ask for legal advice. So, I've argued in every single court in Delaware with a lot of topics. After that, I have a small law office where I help, a lot of my friends, honestly, and some referrals, handle very specific legal problems. And so I have a lot of experience, not only in all areas of law, but these very, very particular things. What I would like to do is give you an idea of how to approach these problems because of how lawyers approach these problems. I'm going to give you some insight on how to deal with problems that are a little bit particular and a little bit harder to solve, especially if you don't have any practical experience. I'm going to start with a really quick story. I was lucky enough to get an email from a student 2 days ago talking about marketable title and deed recording. Right now, the interesting thing about this question, right, is that when I was in law school, the idea of marketable title and recording of a deed seemed so conceptual. It seemed so difficult to understand. But the reality is that I've been a real estate lawyer almost my entire career. So we're working on like almost 20 years. And marketable title and deed recording is one of the more basic fundamental concepts of what it means to do a real estate transaction. Real estate transactions are essentially like selling a house and buying a house, right? The point of marketable title is the idea of you want to make sure that if you buy a house, you don't have any problems that exist from old owners, right? And in general, that problem doesn't really face most average people because you have like title insurance. You have a title company that resolves the problem. And so the issue here is mostly a matter of just making sure that any existing problems are taken care of ahead of time. The deed recording is usually a pretty fundamental basic concept, but I can also understand the idea of why when you're reading the definitions and you're reading these very specific things, it's hard to figure out exactly how do I apply this in context. Now, here's where I come in. My main suggestion here, and this is going to be something that I'm going to provide on the Canvas page of the Delaware Law School section. There's a folder that's going to say non-MBE case law. A suggestion I would make for you would be this. If you're stuck on something, and I know that everybody has their bar providers where these really nice nuanced sections where they'll tell you where you're struggling from individual parts. If you're struggling with something like marketable title, deed recording, the suggestion I would make, and what I have, again, on the Canvas page, is to read cases that relate to that problem. Okay, now, here's what I mean by that. In essence, one of the ways, by the way, that lawyers used to study for the bar is that they would go to the library and they would spend months reading case law, right? Obviously, we've made that They've made that easier now, right? But the idea is that like if you don't know how to look at something, you don't understand exactly how something looks. My suggestion to you is to find cases on Westlaw or on Lexis that resolve that problem in practice. Resolving practice is just to see two main points, right? How is the law stated and how are the facts used? These are going to be two really big things that we're going to focus on in this lecture. Of the idea of, again, I'm not going to teach you family law. But I am going to give you some insights that I got from the questions. I'm going to give you some practical experience that I've had practicing in family law and an idea of how to focus on the law and how to focus on the facts. Now, when you're searching for stuff on Lexis, I can't give you a crash course in legal research right now, particularly. But what I would say is this. My feeling with legal research is that I'm always looking for sentences. I'm not looking for cases. And what I mean by that is that I'm not looking for a broad issue that's particular on something. I want to find a sentence that resolves the problem that I'm looking for. Right now, obviously, as I'm sure, at least I'm hoping most of you know, is the way that we search through Lexis is we have a word, a connector, a word, a connector, a word, right? And so right here you see title \S market exclamation point \S general \S warrant exclamation point \S deed. That might sound complicated, but it's not. I just want a sentence that has title, market, general, warrant, deed, all in the same sentence, right? I want every single case in whatever jurisdiction that may come down to it. I think you can certainly look up Pennsylvania, New Jersey, Delaware, whatever, Maryland. But at the end of the day, I think what you want more than anything is like how are these types of problems resolved? And so when you do this search over here, right? Again, title, market, general, warrant, deed. Again, the exclamation points are root expanders. They essentially give you any variation of the word after the fact. And I'm a bad speller, so I like to use exclamation points to account for words that I don't want to figure out how to spell correctly. Professor Bendistis, really, I'm trying to be honest with everybody here right now. But here's the point, right? A case like that is going to give you something about marketable title, general warranty deeds, or it's also going to give you about marketable title, special warranty deeds, and then the word dispute, which I also like to throw in, right? Or the word element, right? Or prove, right? Words at the end that give a context of like what's a sentence that you want completed. So the point being there is that if you read a case about marketable title and general warranty deeds, you can get a good understanding of like how do courts resolve it? How do they talk about deeds? How do they talk about problems that relate to deeds? Like if you weren't sure about like race notice or race statutes, you could put race, same sentence, notice, same sentence, deed, same sentence, dispute, because maybe folks, it's mostly just a matter of being able to read a little bit more about the law in practice to get a good idea of how it actually works, right? And I think property is a great example of this. Property is a problem of very complex terminology. The vocabulary is different. But as someone who has been to the Delaware Supreme Court on property issues, has done thousands of real estate closings, in practice, real estate in general I tend to think is probably one of the nicer areas of law that you can get into, right? If you do a real estate transaction or a real estate lawyer, yes, buying a house is stressful. Selling a house can certainly, be a nerve-wracking experience, but it's certainly less stressful than getting divorced or getting arrested or getting in a car accident. And so at the end of the day, there's a lot of, days where you leave and people are like happy leaving your office. It doesn't always happen in other areas of law. And so one of the things that I found is that I struggled with property stuff just like everybody else. But when I practiced real estate law, I found that it was actually something that I enjoyed a lot. And I liked doing the litigation because the litigation came down to things of very sophisticated technical issues, right? So when we went to court, the court paid really close attention to us, wanted to know the language, wanted to get it right. But obviously, we were dealing with hundreds of thousands of dollars because you're talking about mortgages and liens and other things. And so I just want to point out the idea that these are only issues because you want to resolve and make sure that the directions are followed. So the thing about property law is it's mostly just a matter of making sure there aren't mistakes and to make sure that when people are doing something, they're doing things correctly. Right. So when you deal with things like, again, marketable title or warranty deeds, you just mostly want to make sure that the I's are dotted and the T's are crossed. Everything's technically exactly correct. That's the priority when it comes to making sure that property law is done correctly. And so these are just a little bit of the insights. And again, My goal, again, is not to teach you the topic, but just mostly to make sure that you understand a little bit of the background of the law and you have a good idea of how this law is practiced, by lawyers to help you answer some of these questions, especially if you had a class that maybe wasn't as practical or maybe if you didn't have the class at all. One of these topics is family law, right? And family law to me is family law is something where when I think I started practicing law, I used to describe family law the same way I described like my taste in music, right? So when people ask you what kind of music you like, everybody says everything but blank, right? Like I talked to someone earlier today and they were like, well, I like everything but screamy stuff. And I was like, I kind of like screamy stuff, so I can't recommend you anything. But I would always be like, well, I like everything but country, right? So I always felt like when people asked me what kind of law I practice, I would say, well, everything but family law, because family law was very scary to me. Because family law is mostly about disputes between two people who hate each other. In practice, that's what I've usually found. That normally when you talk about family law, you're dealing with really intense emotions, right? You get people going through a divorce, people fighting over their kids, right? And in essence, it's a very tense type of law, right? But it's also something that gives the court a lot of discretion, meaning that normally when you're dealing with family law, and again, even if we're talking not about like divorces, let's talk about child custody or juvenile family court. A lot of the way that family law operates is it's a very discretionary standard that allows the court to evaluate the situation to give an answer that's best for everybody, right? For example, you're going to see something called like the best interest of the child standard. The best interest of the child standard is a very discretionary standard given to the court where they're allowed to balance a lot of facts. However, family law also has a lot of really distinct tests, right? To make sure that they can resolve issues in a fair and predictable manner. This is things like amending previous agreements, but it also is things like child custody and resolving, property, right? Again, when you're dealing with like a divorce action, you're dealing with the separation of property, there's a lot of big feelings that come up. And so one of the things that the court wants to do is to say, like, we have a very clear test to make sure when you come in, we're not delineating every little individual thing. And so when we talk about family law, it's sort of a balance of some tests that are very specific, very direct, right? But other tests that allow the court to balance a lot of different elements and factors as a part of it. The main thing is that I think that it's a very factually driven area of law, meaning that like, I have a couple cases that are available on Canvas. And what you're going to see when it comes to things like property division, alimony, child support, is it's very technical. Every single little fact is addressed in every little way. And so to me, if I had a family law question that particularly dealt with things like property division or again, child support or alimony, every little bit there is important because the court has to deal with every little thing. When it comes to deciding things like, child support, like they go over every single line item of the money. They go through every little piece of property. And so the big thing that you want to do when it comes to family law is to make sure that you're addressing all of the relevant facts and make sure nothing's swept over. So be conclusive if you have the time to make sure you're doing everything correctly. This is another area where I also tend to think that you want to lead with your conclusions and explain using all available facts. This level of property belongs to husband. It's this because, it's this because, it's this because, right? The best interests of the child family favor the mom because, right? Avoid the idea of reciting the facts. Try to use as much of the law as possible, especially if you don't have a lot of familiarity with it. The other thing I'll note is that this is an area that does have a lot of counter arguments because, again, it's a discretionary standard. The thing that you don't want to do is give both people's arguments and then pick the winner. I think it's better to lead with who you think is the winner, then deal with counter arguments and address maybe why they might not be correct after the fact. But the big thing with family law is, once again, thinking of the idea of reading a couple family law cases before you walk into the bar exam in case you get a question. Now, I will note some things that, like, not every single bar exam question regarding family law is going to be something. Again, there's two really common factors that I'm going to get to in a second. But the main thing is to make sure that you know what it is that you're going to be looking at before you walk in the door, right? So again, if you've never had family law and you don't have any experience with it whatsoever, take some time to read some decisions. Again, not 6 hours of decisions, but get some familiarity with how the court addresses it, because I find that family law is much more unique than you might give it credit for, and there's a little bit of insight that you can gain from reading those materials. Highly tested subjects. So these are things that are available, at least online. There's a website called the NCBE. It's the National Committee of Bar, or National something of Bar Examiners. I apologize for not knowing the word, but they provide like a collection of essays in the 2010s. And so I read all of them. And these are some common testing topics that usually come up. One, jurisdiction, which court has authority over the situation. You're going to see a little bit of conflict of law things, but to pay some attention to the idea of who has jurisdiction over it and who hears the case. That's a big issue because in a lot of instances, when people do get divorced and they have kids, they move to different states, and then the court has to determine who's allowed to hear it and why they're allowed to hear it. Same thing kind of with divorce actions. There's a little bit of law there that's worth getting into. Custody, alimony, and child support. The two things that you want to know is like what's the test and who wins. Modification is a big deal. And that's a big point because modification is something that comes up in practice. Usually the court will make a rule and then a parent for one reason or another will want to change something. Again, life changes. So it's a common thing that happens that if you practice in the law, you're going to have to know. So just noting the idea that it's not just a matter of establishing it, but noting the fact that things can change and noting when the court can amend it. When do we change alimony? When do we change child support? That's an important thing. Division of property is also a big thing that's commonly tested, the difference between community and marital property. Again, being thorough is very, very important. And then there's also usually commonly a point on application of prenuptial agreements, prenups, right? And usually it's the matter of like, what are the standards that are being enforced? This to me is probably the more common legal point. There's a 4-element test. You just apply the 4-element test. But pay some close attention to, again, custody, alimony, and child support, because as a family law lawyer, those are the more common things that I think are going to come up. To be frank, if I can even go backwards to the property thing, I think one of the reasons why we deal with title and deed recording is because if you don't know how to deal with the title and you don't know how to do the deed, you can cause a lot of real damage to people's houses. I brought up before the idea that like I would go to court and it would be these high amounts of money is because, property costs a lot of money. Mortgages are a lot of money. So when you deal with priority of mortgages, it's like you have to get it right. So one of the things I will note is that it's one of these areas of law that's like very particular and very clear, right? So those are the key things that you want to see here. And it's again mostly a matter of give yourself some time to read some cases because the insight that you gather there, the use of the facts and the use of what the court's doing is going to be really insightful. It's going to give you an upper hand in at very least understanding how the court commonly resolves these type of problems. Corporations is funny, right? And corporations is funny because I think there's two different types of corporate law. And I think that one, at least in my experience, is a lot more common. But I think one is a little bit more well-known, meaning this. There is a world of corporate law that is incredibly complex, right? If you're in Delaware, there are a lot of big firms that deal with really high-level corporate issues. Like even if you look in Delaware case law and Lexis and you put the words Elon Musk in the same sentence, there's a lot of really, really dense, complex cases when it comes to corporate law. However, that is not the extent and the only existence of how corporate law operates. Corporate law can be high-level proxy disputes, poison pills, but it's also a lot of the times just normal business disputes. It's normally the matter of corporate liability and how corporations resolve problems. I have here a lot of corporate law turns on liability because corporate liability significantly affects the ability of creditors or plaintiffs to recover against debtors and defendants. Now, here's something that I found as a lawyer that they did not teach me in law school, or at least I didn't pay attention when they taught it to me, which is that in a lot of instances, being a lawyer, winning a judgment is sometimes the easiest thing, right? Like, for example, I had a client one time that came to my office and he was like, my brother-in-law, I lent him $40,000 and he spent it all on drugs and I want to hire you to get it back. And I was like, listen, man, like I can probably get you a judgment for $40,000, but $40,000 against a guy who's a drug addict is like, I don't know where we're going to get that money. Right? And that becomes the point, is that it's easy to prove whether or not someone is right or wrong in the context of a judgment, but it's an entirely different thing to prove that you're able to get the liability against that person. Corporations often turn on the idea that if you have a judgment against a corporation, it is significantly different than if you have a judgment against that person, right? I have Brett Bendistis LLC, which is an entity that owns nothing, and I have Brett Bendistis, the man, right, who owns, I own a good amount of stuff, not anything crazy, but the idea is that like it means something significantly different. So the idea of corporate liability is so important because if a corporation exists and you're suing a corporation, you often have a much lower ability to recover than if you're suing the person who commits the action. And therefore, this idea of who is liable, the person or the corporation, turns on ideas of corporate formalities, corporate formation, piercing of the corporate veil. And that's a lot of the stuff that comes up in practice. What you will generally find is that people love incorporating their businesses. They don't always understand what it really means. People don't take business meetings. They don't take notes. They should. It's what I like to recommend. But the amount of times I've talked to somebody after they've had a corporation for 10 or 15 years and they've done nothing that you're reading about right now is more often than the people who take really copious specific notes and make sure that all corporate formalities are taken care of. And so, one of the things that you want to make sure of is that you're aware that these corporations actually exist and they exist in the right way. Now, that's not the extent of everything, right? But you're going to get some corporate questions that are very particular and some that are just kind of normal problems that incorporate basic areas of corporate law. So just do a lot of essays is going to be one thing. Because what you're going to find here is that it's a balance of both, and I want to make sure that you're aware of both. To me, I think that these are very technical aspects, and there's some very particular tests that you just want to have some good familiarity with. The tests are often based on terms of art, like the business judgment rule dealing with director liability. There's no clear answer, but a lot of it is considering a lot of fact-intensive considerations, right? You want to make sure in those instances that you are explaining as much as possible. You are giving very particular versions. Although the fact patterns are dense and they're often very technical, they are filled with really, really important information. The one suggestion I might make for you, particularly with corporate law questions, is that you take some time to decipher what it is that you need. There's a really great quote that I've been using, right, for people who talk to me over the last couple of weeks, which is that when you're faced with times of trouble, you don't rise to the level of your potential, but you sink to the level of your practice. It's not a bad one, right? You know where I got that from? Jack Harlow in the White Men Can't Jump remake. Ugh, right? I saw an Instagram clip on it and I was like, that one's going in the holster, right? But the point that I want to note is that like if you sat down for a corporate law question and it's the first time you read it, you would be reasonably terrified. But if you give yourself a little bit of practice, and again, you can go on, just put sample MEEs into Google and just find some and work through them a little bit. Don't read them and then grade the answer. Give yourself the time to write through it because it is, to me, the most important one that if you get a little practice and you get a little comfortable, they actually come along a little easier. Again, I'm not like in a fancy office dealing with big time corporate law, but I've dealt with a lot of corporate things before. And what I find is that there are often things that go to trial because they're often things that balance a lot of factual considerations. They're not super easy cases, but they're also cases that you sort of have to develop a really keen factual record to make it work. So just keep that in mind because, again, it's not as easy as just sort of giving a conclusion or having the right answer, but this is a big part of being able to defend that answer. And so what I have in the folder is some technical cases, some real bench, like the Revlon decision. But I also have like a really simple case about like just an average company that's talking about piercing the corporate veil to give you a balance of both considerations. Now, commonly tested subjects include corporate formalities and corporate formation. Is this a corporation? And what are the consequences if it is or isn't? These are big things practically. Corporate liability versus individual liability, who's responsible for a problem and why, and who are they responsible to? This is another thing where like those are common problems that sort of come up. Again, like what do you have to do? What's taken care of? And this is a part where like, corporate law is dense, but it's mostly just like rules. It's just kind of rules that you sort of need to follow and have a good idea of how they really work. But the big thing that I will note that you're going to see that's going to be the most technical questions, I think. And I think the questions were like, give yourself the opportunity to write through, even if it's not timed to begin with. Intracorporate disputes, directors versus shareholders, derivative actions, business judgment rule, fiduciary duties. Those are things that you want to practice because those are the kind of things where, like, the corporate formality stuff, if you memorize the law and you know the standards, you can work through those. The derivative action, business judgment rule, I can't guarantee that you're going to see it, but if it shows up and you're not comfortable and you haven't written something yet, you could really be put in a bad situation, for lack of a better term, right? You want to have a good answer for every question. That's a part of corporate law that you just really want to have a good idea at. Write some rules. Work through the business judgment rule of how you would say it in your own language, because that's what that question is going to ask of you, right? So again, take some time, Google like business judgment rule, director, fiduciary duty, right? All in one sentence. And again, don't read the crazy cases. You can, you can read Aronson or whatever, but I think in general, like, try to find a fact pattern that seems a little bit more relaxed where you can get a good idea of how it works. You don't have to be a corporate law guru to pass the law in Delaware. I was not, probably still am not. But the idea is that you still want to make sure that you have a good working knowledge of how it works. And I think that if that content seems unfamiliar, or maybe like you didn't have as much with it in the classes, that to me is a really good idea of making sure you check that out, reading some cases and work through the fact patterns to make sure they're there. Secure transactions is funny. It's funny for this reason, right? I have this phrase that I like to do, right? Where when I talk to people, and when you start meeting clients, one of the things that you're always going to hear from a few people, right? It's inevitable, where they'll tell you, they're like, listen, I don't care about the money, I care about the principle. I care about the principle of things. Now, there's no bigger red flag for me than that sentence as a practicing lawyer, right? Because what I have found is that as a lawyer, I can get you money, but I can't get you principle. Meaning that it is very rare that when I would leave litigation, no matter how much I won, no matter whether I lost, no matter how things worked out, nobody was ever glad they went through it. Nobody like patted me on the back and they were like, that was quite a ride and I loved it, right? They were fine with the money that they got, but the idea that people would be like, yes, that was worth the experience is never going to happen. I bring this up because secure transaction is about money. It's about money. That's it, right? You owe somebody some money. How do we make sure we get as much money as possible? And again, this is a hard thing to do as a lawyer. It's certainly, there's a wide amount of law that's just based on debt collection, right? Debt collection is the idea that like somebody owes somebody some money and they hire a lawyer and that lawyer just gets that money for you, right? I don't know if that's like the most fun law in the entire world, but like it's a pretty wide practice of something that people do. And so secure transactions is this idea of like, how do you get money that's owed to you through property of the debtor, right? And I think that there's really two different arguments that you sort of have. I've kind of been on both sides of this, probably more with real property rather than more with real property than personal property. But a lot of this stuff deals with things of creditor versus debtor, right? But also creditor versus creditor. So it's a matter of like, yes, you want to make sure that you're aware of the perfecting of the security interests is what are filings you have to make, like the establishing the security. However, the idea of lien priority is really important. The idea that two different people have a competing interest in a property, that is something that not only happens in practice, but it's something that you're going to see on the bar exam a lot. And so making sure that you see those questions, you're aware of those rules, and that those have a good amount of like, you have some familiarity and comfortability with those, I think are really important. The other thing I found here is that, again, I don't want to be like, oh, just make sure you apply the facts, because obviously the facts are important. But I find that secure transactions is a lot like contract law. Contract law is the kind of thing where it's like, it's this, then this, then this, then this. It's a very linear rule, which I recognize is just like a term for me that means like it's a very complex amount of things that all need to be proven in order to establish something. To me, again, it's a part of the UCC terminology. And so the idea here is that like all of these conditions, all these things that need to be proven are all there for a reason. And they're all really, really important. And so to me, although, securities transactions, I think secure transactions is dense, right? It's kind of dense for a reason. And it's also dense for a reason because it's, again, very technical. And so this might be an area where, like, yeah, read the questions, right? But I found that when I read a lot of secured transactions questions, they were all kind of the same, right? It was like, here's a list of property. Can they get it? Who's better at it, this person or the bank? And so when you look over here and you see like the common questions, right? Creation and validity of security interest, and then disputes between different owners and creditors, creditor versus debtor, other creditor, third party purchasers, for example. I find that like it's a very common fact pattern, but the rules are really particular. And so this would be maybe a place where, again, if I didn't have as much familiarity, again, read the cases absolutely, but put a little extra time into making sure that those rules are really clear. Go through the essays to make sure, oh, am I spotting the right rules, and reading the answers to make sure that the rules are really correct. In some instances, I think that people focus so much on the answer, the issue spotting. And certainly, I don't want to discount the value in issue spotting. But I also tend to think that there are certain areas where you can actually get a lot from the idea of like, are the rules they're saying the rules that I've also put down? This to me is an area that I would include that. And so again, read some cases on it, but note the fact that when you read the sample answers, they're very, very specific. They want to make sure all those points are really proven. So to me, I can remember this being a place where I was just very particular with memorizing, really trying to make sure that I had a good familiarity with those few points. If there's a rule that requires certain points, I hit all of them. And to me, that would be the attention that I would put in this area in particular. Wills and trusts. So wills and trusts is tough, right? As I have here in the sentence, descendants and states is a problem about how to resolve someone's property or money after they die, right? Who gets what and why do they get it? I've dealt with a lot of wills and trust work, and I feel like when I was in law school, I remember thinking like, how often do undue influence cases really come up? How often is it you've got someone on the deathbed and there's somebody who comes in and tries to change their will, or there's like a person who tries to get romantically involved with them and take all their stuff? It happens all the time, right? I was like kind of surprised. I always thought it was like, oh, you're just making wills and that's it. But it was really enlightening in a sense to note how substantive this area of law is. I will also tell you, this is some unsolicited advice. This is an area where, as a practicing lawyer, it gets real ugly really quickly. I have this story I like to tell where if you have siblings, right? I have two sisters, they're great. If I had to think of like two people who could say things that would really hurt my feelings, it would be my sisters because they've known me my whole life. And so I had a case where I was in a deposition with some family members, and it just got really ugly really quickly. I called my sister when I left, and I was like, "Ha, I love you. We're not going to fight." There's no amount of money where, again, I hope my parents just like live forever, but there's no amount of money that would allow me to want to get involved in that type of litigation, right? Because it's hard, because you have to sort of predict what someone was thinking, what someone was feeling, what someone would want. And it has a lot of like really turbocharged feelings that are associated with it, right? Whether or not that factors in the bar exam, I don't know. I'm just pointing out the idea that it's a very sensitive area of figuring out what people think and how they feel about things, how to predict what a person who is no longer here and can't testify for themselves wanted based on their actions. Now, in general, wills and trusts are really focusing on specific documents, wills, trusts, power of attorneys, and the legal effect of them. Now, normally the resolution comes from the documents and the laws that govern the issues, right? Kind of same thing with the trust, where trust issues about the powers and the authorities of each named person. I think in general, this is only my personal opinion, is that trust language is more technical, but the areas are kind of similar. There's a reason why like wills and trusts are usually lumped together. And so I think that trusts are a little bit more technical. I think it's a matter of, again, working through the problem really particularly. But I've also included some wills and some trust cases just so you can read it and see what kind of analysis the court uses, what kind of facts the court uses, because these are going to be really important things to sort of get an idea of, again, how should you really approach this problem. There's no problem on any bar exit question where the answer matters more than the analysis, right? This to me is something where the idea of trying to predict what somebody intended, right? What is the consequence of somebody's actions? That's what wills and trusts ultimately come down to. Now, when it comes to commonly tested topics, right, you're going to look at the validity of estate documents and the effect of noncompliance. Is a will valid? And if not, how does the state resolve the issue? The main thing is that like wills and trust cases need a resolution, right? And so one of the things that I often find with wills and trust cases is that like commonly things are not done as well as they should, and then the court has to sort of fill in the gaps and like get to a resolution, because at the end of the day, if somebody dies with $1 million and they don't have their will correct, it's not like the state's like, oh, too bad, like, well, we kind of got to figure it out one way or another. And so you have to deal with things like spouse elective shares. You have to deal with things like what is the intestate succession standards, right? And so these are things that are important, because you want to be able to show that like, there's not something that's just left up to chance or left to nothing, right? We have to figure out where things go and how they go. And again, ideally everybody's will is great, but wills are usually not, commonly not. Let's go with that far, right? But the idea is that like the resolution of a will is sort of also kind of often tied into the idea of like, what happens if the will isn't good? We also want to talk a lot about like the authority of a person to act on behalf of the decedent, right? Should the person have used another property? Should they have taken action pursuant to a power of attorney? That's a big one. There it's a tough situation, because what you often find, and again, I'm at this sort of age where I have like young kids and my parents are older, right? And so there's a point where even if it's not me, there are people around me who are taking more care of their parents than I did when I was 25, right? And the idea of taking care of somebody often includes the idea of like managing money, managing accounts, buying a house for somebody, really putting their life in order. And sometimes what happens is that like when one sibling does it, well, another sibling gets mad. That resolution of like, what's the responsibility of someone to be able to do something, and the fiduciary duties that are related to that relationship are not only highly tested, but they're highly litigated. And so make sure you know the idea of like, what does it mean when one certain person's acting on behalf of another, and how do you resolve that issue in practice? Finally, the authority of a person to act pursuant to a document. Trusts in these types of documents are very controlling in the situation, and they deal with a lot of things comparable to contract actions, like interpretation, ambiguity, things like that. But if they're unambiguous and they direct you to do something, that's the thing that you have to do, right? So the idea there of like noticing the interpretation of a document and how they work, I think, is important. With trusts, again, note the terminology really clearly. Know who the people are: beneficiaries, settlers, trustees. Get a good idea of that relationship. Now, the other point I will note is that yes, bar exam work is great. Read the lectures. Don't let me change your mind, right? But another place that you could sort of commonly look at is secondary authority. Like if you go on Westlaw or Lexis, there's the American jurisprudence, and there's often texts and treatises that have information that's there to teach you. They're to teach you stuff, right? And so if you're finding that the resource you are using isn't teaching it to you the way that you want to, well, like, look somewhere else. Delaware Law School is still open, the library is still open. And so I just want to point out the idea that like you are not in a box of your own design, but that you can also look to other areas to get some extra insight into stuff. And so I tend to think that like, yeah, read some trust cases. There's trust cases everywhere. Trusts are always litigated. And this is another area where trust, more particular than wills, in my opinion, work through some fact patterns. Look through some essays, and not just a matter of like, I'm reading it and I'm reading the answer. Trust questions in particular to me is like, you got to be able to write them out. You got to make sure that you're aware of them, because you're going to get something on the bar exam that's hard. You're not going to get an easy bar, right? Don't take anything to chance. In another life, when I didn't have children, I wanted to get really good at chess, right? I wanted to get really good at chess. And I'm like, I'm okay. I'm better than people who don't know anything, and I'm significantly less good as people who like are like real good, But the thing that I learned, like the biggest thing that jumped me from like being actively bad to being like mediocre, is that like you account for the fact that everyone makes their best move. Like you don't play a game of chess hoping that someone doesn't know what you're going to do. You play it with the assumption that the other person does know what you're going to do, right? I want you to kind of take that same approach with the bar exam, where like, don't allow there to be a single topic that you're like, I hope that's not on there. Because you could get lucky, but why chance it, right? And if there are things that you don't know about, again, there are ways to focus on it. Sample essays, sample MBEs, reading cases, reading secondary authority, get a good understanding of it. Because if the outline and the material isn't clicking with you, one, email me. I'm happy to talk. I've got nothing to do, right? But more so, like, there are just ways that you can teach yourself stuff, and these are areas where I think the more you can teach yourself the things, the better off you're going to be. Lastly, let's talk two topics really, really quickly, and I only bring these up because these are sort of, to me, derivative of other areas of law, and I think these kind of speak for themselves a little bit. Conflict of laws, to me, is comparable to civil procedure. It's like the cousin of civil procedure. And like the laws are, I really liked conflict of laws. I had a teacher for civil procedure who terrified me, who like I scared every single day that I went to class. And then I had that teacher again for conflict of laws, and like it was the nicest, easiest class I ever had. I got like an A+ in it, right? And I was like, oh, this first year law school teacher is actually like a really, really nice person. But I liked conflict of laws. I liked it because it was something of, I find that a lot of civil procedure, personal jurisdiction, subject matter jurisdiction, is like, are you able to identify the easy things that prove your problem, right? Are you able to avoid that trap of just giving me an answer or reciting the facts? And so conflict of laws is something where, again, you can very easily full faith credit conflict laws, dispute, Erie doctrine, resolution, it's just things like that, and just read the cases, right? And what I think that you'll find is that it's a matter of like, don't let it become something that trips you up because you don't give it its full faith and credit. Am I right, folks? Agency law is just determining liability based on actions. I find that like a good approach here is leading with conclusions and applying all valid facts. Who's responsible for what happened? I've always found agency law to be a little bit on the easier side. I mean, obviously you're dealing with like employment law and other things. I think it's mostly a memorization of the facts and being aware of how the problems are commonly tested. I find that, again, they're usually something where if you get a little bit of practice in, both of these are a little bit there. I would just point out the idea of work through the essays, especially if you didn't take conflict of laws or if you didn't take an agency or an employment law class. Working through those problems, I think, is just a really key thing that's going to give you a hand. So that's our lecture for today, right? Well, bar exam's coming up. It's really close. I recognize all the things. I'm going to advocate for a few things before I go. First thing I want to suggest is this. Give yourself a day that you just very clearly determine right now that you're going to have like a full day of MBE and maybe a full day of essays. Again, I think I've told the story, but I thought that taking a full day of Delaware law essays is the best thing that I did. It's the absolute best thing that I did. It gave me the speed, the tempo, the stamina to know kind of like where I was and what I was doing. I'm like a caffeine person, and so to me, if I was going to take the exam again, I would really want to know, like, well, what is it that I'm going to drink that's going to give me the most amount of attention all the way through? Like I would probably have I like tea, and then I like disgusting poisonous Monster energy drinks. And so what I would do is I would have like a good amount of caffeine in the morning. I would wake up and give myself time, right? And then in the afternoon, I would just like as much power as I can to get me kind of through the day. But I would test that. The other thing I would prepare is that if you're 2 weeks away, think about the idea of like, are you on the right bedtime? Is your schedule getting correct? Are you starting to get yourself in a groove of like, this is what we are doing every single day? That way, when the exam comes, you're not changing what it is that your schedule is, right? So those are just some things to think about. I would, again, very highly advocate the idea of give yourself one more chance to do essays, one more chance to do an MBA. And again, if you have any questions, my email address is right above. More than happy to give you a hand with anything that you need. Good luck with everything. Again, focus, study hard. Don't burn yourself out. But now's a really good time to really focus on your studying, your memorization, your essays. And good luck. You're all going to be fine. And I'll see you at least one more time before the bar exam.
Pass the bar. You're going to pass the bar in these lectures. lecture short, you'll get good at torts. Know the laws you've got to know.